Hi, I'm Jen Rubin, editor-in-chief of The Contrarian. I bet you're concerned about privacy more than you used to be. With Elon Musk and his tech bros pawing through the government and looking at tax information, health information, I am sure it has gone through your mind that there's information that the government collects that you would prefer that private individuals who have large social media platforms do not have. And what better person to explain privacy to us than Daniel Solove? He is the author of a new book, which is very timely. It is called On Privacy and Technology. Welcome, Daniel.
Thanks. I'm really thrilled to be here.
Terrific. We're glad to have you. So, what was the inspiration for this book?
Well, I've been writing and thinking about privacy for a very long time, about a quarter century. And a number of years ago, I read Snyder's On Tyranny. And I was really struck by how powerful the book was, how he synthesized his thought in such a succinct way. And I thought that this would be a great thing to do for my thinking on privacy and technology. And so I aimed to create a book somewhat like his. I wasn't able to be quite as succinct as he was, but succinct for me at least.
And it's a very easy to read book. It's very small, less than 100 pages. So, what are some of the basic concepts that you wanted to get across to people? The book is written for people who aren't lawyers. I'm sure lawyers will read it, but it's made to be, I think, accessible to non-lawyers as well. What are some of the basic concepts you want people to understand?
Well, a few takeaways are that there are a lot of myths that persist on technology and privacy that impede the law from success. And success is, can the law keep up with the new technologies that we're facing? We're living in an age of AI and big data and ubiquitous surveillance. Can the law keep up? And there's a lot of hopelessness that the law can't really address these problems, that the law can't run fast enough to keep up with technology. And the book, I want to dispel the myths that lead to that belief, which I think is false. The law can keep up, but there's just a lot that gets in the way. And technology is treated differently than other things. And as a result, that the creators and users of technology are just not being held accountable for the harms that they're creating.
Right.
And the incentives are all wrong. And if we focus on that, if we focus on holding them accountable and creating the right incentives, the law can, in fact, keep up with technology and can protect our privacy, but only if the law does those things. And right now, it's not doing those things.
We often hear that we can't regulate technology because of the First Amendment. This, you argue, is a dodge, that there's a difference between regulating the way technology operates and to some degree the software and the content of people's speech. Explain the difference between the two and why it's perfectly okay to regulate the non-speech part of that equation.
Yeah, I think unfortunately, First Amendment jurisprudence has kind of lost its way, and the First Amendment is used as a tool to kind of whack all types of regulation down. And I think it's misused. It's going far beyond its intention, which is to protect robust speech in a democracy. And it's then become a kind of a corporate tool to do whatever they want, to collect and use data to control people's behavior, manipulate people's behavior, make a profit. But that's not speech. It is the use of data, the collection of data, the transfer of data. But that's not really what free speech is about. But unfortunately, free speech is being used by them as a way to try to protect this profit-making activity. But actually, ironically, that undermines the very goals of why we have free speech. We have free speech because we want a democratic society where people are free to express themselves and develop themselves in their uniqueness and autonomy. But in fact, what we see is that these uses of the technologies are actually undermining people's technology, are controlling them and manipulating and stifling their speech, and are aggrandizing the power of the platform companies. Uh, but that's and undermining democracy. So this is the opposite of what free speech is for.
Moving to a little bit of a lightning round, I'll ask you if the following things implicate free speech at all, if it creates any kind of free speech. Um, the collection and sale of your personal data. Does that invoke the First Amendment?
Not really, no. Collecting data is not speech. It's just collecting data. So that's not speech. As far as the sale of data, generally, I'm not sure that really involves speech either. It's selling a thing. Is it really communicating a message? Is it expressing something? I don't think it is.
Right.
It's just selling something to make money.
Here's a one that tends to trip people up. What about the algorithm itself, the code that says what message is going to be put in front of you and helps select and prioritize what you see on social media? Is that protected speech?
I actually think it is speech, but there's a way that it should be regulated, and unfortunately, it's not regulated properly. So I think it's speech, but the platforms kind of want to have it both ways. So when it comes to the First Amendment, they say um, it's it's speech, protect us. But then there's a law called CDA Section 230, the Communications Decency Act Section 230, which provides immunity for platforms for the speech of others. And so they turn around and say, oh, we're not speaking, it's someone else's speech when it comes to what's on our platforms. Well, you can't have it both ways. If you're saying that your curation and your ordering and the things you deliver to people's feeds or you're speaking, well, then you can't turn around and say, well, I should be immunized because it's not my speaking. And I think if we then let the law do its job, which is that if you're speaking and you, through reckless or intentional behavior, harm other people. You defame them, you invade their privacy, you hurt them in certain ways or cause harm, you could be liable to them. They can sue you and you're held responsible. Right now, what they have is the protection of the First Amendment as speakers, and then they also turn around and claim, well, now we get immunity because we're not speakers. And the result is they're not held accountable for
Right.
harms that they're creating to others. So I think it's actually would be good to say, yes, your speakers, your algorithms are speaking, but now you got to own the consequences of what they're doing. And you should be responsible for the harms, just like everybody else is responsible for the harms that they cause. If a newspaper publishes something that defames someone or invades their privacy, they can be sued. And so
Right.
should a platform, even though their algorithm is doing it.
So if you are normally talking apart from the technology about the First Amendment, usually the offense has to come from a state actor. In other words, the government is punishing you in some way, or the court is awarding you damages so that you vindicate some other right. In the case of these platforms, are they government action? Do they constitute a government player in the world of technology and speech, or are they simply private actors that can do pretty much what they want?
Well, they're private actors. They can't do whatever they want. So the First Amendment protects a private actor in speaking, but it does not give them sort of absolute rights to say whatever they want. So I can speak, but I can't defame somebody. I can be sued for that. And the First Amendment protects in certain things where the courts are the government is actually invoked in a lawsuit. It's using its power to help a private citizen sue another private entity. So the First Amendment's implicated, but generally, the First Amendment is consistent with defamation law. It doesn't bar all defamation claims. Invasion of privacy suits are also okay under the First Amendment under certain circumstances. There are protections for speech that are built into that, but there's also instances where there is liability for causing people harm, through speech. And so that's where this comes in. The platforms are not government, but they are engaging in speech. And that speech, when it harms other people or defames them or invades their privacy, a private individual should be able to go to court and seek redress. And that's consistent with the First Amendment. What's standing in the way is this law, the CDA 230, that immunizes them, that goes
Right.
far beyond the First Amendment goes. And I think that's the problem.
Yes. Now, do you advocate getting rid of 230 altogether or simply to modify it in some significant way?
Ironically, I think if we go back to what the CDA actually says, the actual words and intention of the CDA before it got twisted by courts, that's what I think would be great. The CDA as written and as intended is exactly right, which is that if I have a platform, and someone else posts something and I don't know about it, and I shouldn't be responsible for just that being posted. That's, I think, what CDA actually says. And that makes sense. But once I know that it's harming somebody, or I'm facilitating or encouraging that speech, or I have an algorithm that's curating that speech and pushing it up into everybody's feeds, I think that's a totally different ballgame. And I should be responsible as a platform for that. And the problem is that courts have taken this law and expanded it in an activist way to do all sorts of things that it doesn't say and wasn't intended to do. And so I would restore the CDA to say, let's actually interpret this law as written.
Now, one reason for putting that law into effect, and it's peculiar because other forms of media, of course, don't have that. Newspapers get sued all the time, and magazines, all sorts of other kind of media, individual speakers get sued. One of the reasons was that we wanted to help a developing industry. We didn't want to kill the internet in the crib. Now these are some of the biggest companies, and the concern is at the other end of the spectrum, which is they're too big. Maybe they're monopolistic. Maybe they've bought competitors, or they are fixing prices in some way. If we are no longer in the situation where we have to nurture these, is this further reason for regulation that might include not only speech, but other aspects of their business?
Yeah, I think for a very long time, the law has treated technology as special. That if we want innovation, this myth goes, we have to barely regulate technology. Just let them do whatever they want to do, harms what may, because if we don't, we're going to ruin innovation. And I think this is totally wrong. I think that ultimately companies need to be held accountable for what they're creating. And I don't think regulation harms innovation. It steers or directs innovation. So think about it like an analogy would be to cars, right? You a seatbelt is just as innovative as a gas pedal. A seatbelt or a safety thing in a car, that's innovation too. Good gas mileage is innovation in a car. Um, the law needs to steer things toward that kind of innovation. So I think it's wrong when tech companies, well, all regulation is just stifling innovation. It's channeling their innovation so that they innovate. How do you create technologies that are socially responsible, that don't harm individuals, that are safe to use? That is innovation. And the law can make companies innovate in that way rather than to innovate just to move fast and break things and harm people and make a big profit. And if I think the law forces them to innovate in these ways, we'll get much better outcomes. They still can innovate, but that innovation needs to be channeled in ways that are helpful to people in society. And that's not what's going on. And other industries have to do that, right? We regulate cars, we regulate food, we have in every other area and every other product. If the product causes a harm, you can be sued. Uh, we have food safety. You can't go to a supermarket and buy, milk that's just going to possibly kill you. Although with this
Who
administration,
knows now?
that might go out
Yes.
the window. But generally, it's nice to know when I go to the supermarket, I don't have to go and research the farms of the milk. I don't have to become an expert in pasteurization. I don't have to, I can just buy the milk and know that it's safe. And then know that someone has my back and has looked at the farms and is checking and hopefully making sure that they're following the rules. And then if I am harmed, I can sue too. With technology, we have problems on the front end and the back end. On the front end, no one's looking out to see if what they're making is safe at all. And there's no incentive for them to make anything safe. And then if they do make something that harms somebody, the law seems to go out of its way to give the companies a pass. Oh, we want them to innovate. Oh my gosh, it's just too hard for them to worry about making it okay or safe. Oh, there's no harm. We just won't recognize a harm. Oh, there's no standing. They find every excuse to give the technology companies a pass. And I'm just saying, why not just hold them to the same standards that we've held everyone else to throughout history? And it took a big battle to get food to be safe, it took a big battle to get cars to be safe. Now we're with digital technologies, and it's the same battle. And we see the same arguments trotted out every time that we saw in the debate with car safety. Oh, we can't do it. Oh, consumers don't want to, they don't want safe cars. With the food, oh my gosh, we won't have food. We can't do what we do. We'll go bankrupt. We hear the tantrum every time that the regulation comes around. And I think it's about time to realize it's a tantrum, and the
Yes.
regulation works if it's effective. And the key is companies need to be held accountable. The incentives need to be right. You do those things, you get much better results.
Well, I think if there's one big takeaway from the book, it's that we can have the system we want. We are not prisoners simply because these people flashed their First Amendment card around, that we can actually create a better system, one that we like. Let me shift gears while we have a privacy expert to something that's quite different. And that is what government does with a lot of private information that it collects. It's your tax information, health information, criminal records, background check information, all kinds of information. And now there is great concern that someone who has not been vetted, who is, his status is unclear whether he's a federal employee or not, and a bunch of his young employees are getting access to all this data. Is that a violation of privacy? Is the government allowed to just pass it on to whomever it wants, or are there restrictions on who can see this information that the government collects?
Definitely laws and rules that are likely being violated here. The government can't just decide to do whatever it wants with people's information. There's the Privacy Act, a law passed in the wake of Watergate to protect privacy of information held by government agencies. And Yeah, there's a lot of the law has its problems. It's weak. It certainly needs to be fixed. But the things that we're seeing are very egregious actions that seem to be done without any kind of legal review or analysis. They just do them because it's cool. It's the kind of same ethos of the tech world. Let's just do it. The law schmaw. We'll just do what we want to do, and then worry about the consequences later. Ultimately, though, we'll see what happens. There are lawsuits, that could enjoin what's going on.
Right.
There could be damages that could be imposed. But at the end of the day, they're going to be paid out by the federal government, which is, it's not Musk paying the damages himself. So, it's like, okay, it's like the taxpayer pays the taxpayer for the harm caused to the taxpayer. So we need something stronger. There also is there are constitutional rights as well. There is a constitutional right to information privacy that does restrict the government from disclosing personal data that in an unwarranted way. So that's also something that could be potentially used. So there are
Well,
definitely legal tools that, if properly applied, would restrict some of this. But I think those tools are still not quite strong enough in this case, just because even if you apply the tools, it doesn't create the right incentives. The incentive I'd like to see is, by doing this, you are set back, in a way that stings so much that it sends the message, don't do it.
yes.
And you shouldn't do it. And I'm not sure that that's what's going to happen. At best, it's kind of like, okay, you get a slap or you get some, stop it or sin no more. But I think we need a bigger rebuff. We'll see if the courts are up to that in when we see these cases. But I think generally, as a whole, when I see privacy enforcement, it typically involves the enforcement is often not enough to create the incentives needed. I think you need like really strong punishments and really big damages and really robust enforcement that's swift and uh, dissuasive. And what we find with enforcement generally is it's not that. And so, companies realize better to ask for forgiveness than ask for punishment.
Well, I certainly agree that with billionaires, you're going to need a much more robust enforcement system than the one we already have. Well, thank you so much for joining us, Daniel. The privacy issue is a burgeoning one. I think it's poorly understood in part because politicians can barely read emails and they don't know how their own phones operate, sadly enough. So we get lots of clumsy attempts. And frankly, they get bullied and intimidated from investigating and regulating as they should. But thank you again, Daniel. The book is on privacy and technology. It's well worth a read. Thank you. We'll see you again soon.